segue to another topic. Let's go and move to a situation where I think a lot of people get confused about vesting title, how to take title, having a will versus a trust. We got Joe Dragon over here. He's an attorney. He knows all about this. Also, Rich is an attorney. So, guys, I'm going to let you guys have the platform here, but let's kind of go through some instances where somebody's actually either benefited or not benefited from a situation not vesting title right.
Well, what do you mean?
Well, let's say that
titling a house.
Titling a house.
How do you title a house?
Okay, all right. Well, I mean, typically everything you do is going to go through escrow, right? That's a common.
Correct.
You don't have to use escrow, but there's a reason people do. And what escrow does is, for those that don't know, they do things like inspections, but primarily the big thing they're doing is they are the title company looks at everything that's been recorded on the property ever since it became a property. So that goes back to BLM land. They trace it from that point all the way to the point that you're purchasing it. So all the owners, all the liens, everything that's ever been recorded against the property. And what they are looking for is that you have what's called marketable title, right? That the person selling the title is free and clear of any other potential person or entity that could say they have superior title. It's a little complex, but property law is basically saying first in time, first in right. The first person to claim it is the first person to have it. Once they go through that process and they say, yes, they're selling you marketable title, they issue you title insurance. It's like $300 and basically say, not only do you have it clear, but if we're wrong about that, right, we have insurance that will cover that. All right. And that typically somebody has a lien, right? Let's say somebody had a mechanic's lien, right? Somebody does work on your property and you never pay them $30,000, right? And then record a lien against that property. Then you sell the property. Well, guess what? That mechanic's lien has seniority over the person that's buying. So that's the purpose of going through title.
Okay.
So the first thing I'd say is if you get in a situation after you buy a house and assuming you went through escrow and somebody comes knocking on your door or suing you, understand you have title insurance. So if you need to respond to a lawsuit, call the title insurance company. I think that does happen when people don't realize that and they try to defend themselves. Not too often, but it does happen. If you don't use title, you can do that all yourself. I would not recommend it. And really the only time you're going to do that is when the title insurance company will not issue. And usually that's because of a foreclosure, like an HOA foreclosure, a bank foreclosure, or something like that where you go through escrow. Those are discounted properties for that reason. You can have an attorney look into the title and say at least, okay, this is what I think is going to happen. You can do it that way. Does that answer your question? What do you get?
Well, I think another thing that people are really confusing is how do you title the property? Do you do it joint tenants? Do you need to get a trust? Is a will good enough? Those types of things.
Let me debut my slogan because I think this is very important.
Well, you got a slogan, okay?
I do.
He created this.
Listen, hold on.
How long did that take? That slogan? Were you sitting like a mad scientist?
No. This just came up. This just came up over time working with people. Okay, here it is. Being cheap can be very expensive. Do not do your own deeds and do not do your own estate planning because you will screw it up.
Explain how you would screw that up though. Like where did somebody screw up?
Let me give you a classic example that I hear about a lot. You'll have an older couple and they got a kid and they say, oh, I want to make sure that my kid is going to have access, that they'll be able to inherit this house. So I'm going to add them onto the title.
This is a great one.
Okay. So Rich, take it away.
Okay. So let's say this is your situation and you say, I'm going to put my kid on title so that they can inherit the house easily, and I don't have to go do a will, and I don't have to go do a trust or anything like that.
And it avoids probate, which is true.
And it's, so you can do
only
this thing,
for that specific asset.
Only for that specific asset.
Right. Yeah.
So let's say what you do is let's say you're a married couple and you're both still alive. Okay.
Yeah.
And you hold the house. You hold the house probably in something called joint tenancy, and they probably did this for you properly when you went and bought the house. And
the title company did.
The title
right?
company went, escrow and title are usually linked here in Nevada.
Yep.
And the title, you get title insurance, and your escrow company, they make sure it's titled properly, and you get the deed, and it's held in joint tenancy. And so what joint tenancy means is that upon the death of one of the joint tenant holders, the other joint tenant automatically becomes the owner of the property in full. It doesn't go through
We're jamming.
Oh man, it's magical.
Hey, was that something like coming in as you're talking? It's like, what the hell is that, man?
It's like an alarm.
It's not me. It's not me.
Wow. Okay.
But yeah, so basically joint tenancy, it's great if you own the house with someone like a spouse. And basically when one of them dies, it becomes the other's property in full. It doesn't go through probate.
What's going on? Turn that off. What is that, man? Is that your phone?
It's not my phone. It's not my watch.
I wonder what that is. Mike, are you doing something over here,
it's
Mike?
not me.
Mike? I don't know what that is.
Okay.
That's got to be coming from your board, isn't it?
I don't know, man. I think it's coming from somewhere. Go ahead.
Okay, so anyway, so the joint tenancy is great because it doesn't go through probate. You don't have to use a will or trust or anything. It just automatically goes to the other joint tenant holder. So, but let's say in this situation, you're a married couple and you bring your son in because you think, well, we know how it works and we don't want to deal with this. We don't want to go to an attorney and they do their own deed and they try and put it in joint tenancy. And let's say they actually do it right. Let's say they actually get it done right, which happens from time to time. So they get it in joint tenancy, and then let's say dad dies. So then dad dies.
Poor dad.
Poor dad. Dad dies. And now the house is owned by mom and son as joint tenants.
Right.
Everything's going fine. And then mom dies, and now the son has the house. Now the house becomes the son's fully. So you got through probate. You didn't do anything of that. However, there is this thing called taxes that becomes a big issue if you do this. Yes, and so this is something that happens often for people. So let's say that mom and dad bought the house for like $100,000, and when they both died and son inherited the house, it's now worth, let's say, $500,000.
Okay.
Let's say,
Let's
say it's Las Vegas. Let's say they bought the house 10 years ago, and now it's worth $500,000.
Yeah.
Which could have happened here because we had a pretty big price appreciation over 10 years. So now son, unfortunately, what son is going to do is if he sells the house, he's going to have this thing called capital gains. And what capital gains basically are is, what did you buy the house for? What did you sell it for?
Right.
So we're going to do this we're just going to keep it very rough, but let's just say 500 minus 100. So let's say he had 400,000 in capital gains. Now, see, if mom and dad had simply kept the house in joint tenancy with themselves and passed the house on to son without putting him on title that way, he would have inherited the house at what they call the date of death value. And then if he immediately sold it, he wouldn't have had any capital gains.
Step-up basis.
Step-up basis.
That's called
yes.
a step-up basis.
And so there's this thing in tax law and in succession law that when you inherit property from someone, that instead of getting it at the value that they paid for it, you get it at the value that it was when they passed away. And it's a great way to get around estate tax and all that stuff, but that's not really the point. The point is just that if by not seeing an attorney or a tax person and finding out about this and thinking, well, I'm going to avoid the cost of probate and put my son on in joint tenancy, you did do that right, but now you've left them with capital gains on $400,000.
Now, would you use a will or would you use a trust in that scenario?
Okay, well, now you could do it either way, depending on your personal situation.
So,
but
isn't there a benefit of the trust though? Because then you avoid the probate situation.
No, of course there are benefits to the trust. Yes. No, I'm just saying that you could effectuate the process either way by will or trust.
Let me say this. Go ahead, Mike. Go ahead.
I read a case study on somebody. It was a mother who owned a bunch of rental properties, and she wanted to start doing some estate planning. So she was doing what we talked about, put her son on as title. Well, turns out her son did not pay his income taxes. And so the IRS comes knocking at his door, and they force a sale of some of the rental properties that mom put his name on. And this was really kind of crazy because what happened was they forced the sale of it. Now they decided that these properties are half owned by mom, half owned by the son. And so they took the son's half and gave mom her half. So they didn't steal her money, but they took what they considered to be the son's half. Now, he put no money in there. And they went before a tax court and argued this. But the IRS prevailed. And because she put her son on,
He owns
lost
the asset half, so that's how many that is. Now, would a trust protect the mom in that situation?
So all right. So the great thing about that too is that let's say you want to do it the right way, and let's say
that sounds good.
Yeah,
Tell
let's
us
say
how.
you want to do it the right way. So what Mike was talking about, of course, is that she's given her son half the property. So now any of his debts, creditors can come after him. The IRS being one of the scariest creditors, but they're not the only creditor. Anyone could come after him for debts that he owed, and they could.
He could hit a school bus full of kids, and then what happens?
And he could get a huge personal injury, judgment against him, and they could come after him.
Hope he
So
has
that's another
insurance.
problem. That's true, but you could go in excess of the policy limits, and you could still have lots of debts to pay. You could have domestic support obligation. I mean, you could have all kinds of things. I mean, if you've given someone your property, it's their property now, and they could lose it basically. So that's always a big problem. But but of course, if you basically a trust is wonderful because we'll skip a few steps. So we'll just say, but if you get a trust, basically it's still your property. So, but a trust is sort of this like fictional person, like a corporation, basically.
Yeah, it works the same way a corporation does.
Yeah, it works very similarly. And one of the biggest reasons is that people get trusts let's just say not one of the, let's just say like the common reason that the average Joe would get a trust for most
like
of
this
us.
Joe here.
Yeah, like this Joe.
Average.
Yeah, well, I mean, Joe's not average, of course, but
No.
but
Joe
no,
Dragon's
let's just say someone who's not worth millions.
I got a lot of hair,
dollars,
so it's not average.
Did you have to bring that up?
Moving on. I'm sorry.
But no, the great thing about the trust is that why most of us would get a trust who are not worth millions of dollars is to bypass probate. But also, let's say you had a home and you wanted to pass it on to your heirs, but you didn't want to open them up to their creditors, and you also didn't want to cause a tax problem. And you also wanted to avoid probate, you put it in a trust. And a trust is great because basically what happens when you put something in a trust is it's like a company, it's like a corporation. You name yourself as trustee of your trust.
The manager of the corporation.
Yeah, the manager of the corporation, so to speak. And it's still your house. You're still managing everything. But when you put this trust together, you can put a lot of stuff in it. You can name all kinds of, who you want to go to, how you want it to be managed, whatever. Trusts are great. You can put all kinds of stuff in
So
it.
with Mike's situation, when you talked about the IRS coming after, do you think the trust would have protected her?
Well, sure, because she would have never given it to her son. It would still be her property.
He would never have been an owner.
Yeah, he would have never been an owner.
And it's a really simple transaction.
Yeah,
isn't it?
and it would have never. Now,
What is the cost typically for something like that to get set up on a trust? Like if you wanted to say, I want to set this up, put my properties in a trust, what do you do on that?
Well, me, it's very reasonable. 500,000.
Okay.
Okay. Yeah.
Sign me up for 3.
It just depends. I don't want to give the answer. It depends.
I
but
mean, there's a lot of. I would say there's a lot of difference in market rate for people.
yeah, if you did something simple and you just said, all I want to do is put this piece of property in the trust, I mean, I wouldn't.
I mean, but like okay,
$400 at the most. But if you say I want to make a complex trust, I mean, I don't know what you think, but with lots of different things in it, operates in lots of different scenarios. Well, that gets more expensive. It just depends how much time goes into actually doing that. But for something very simple, it doesn't cost a lot.
Do you have to, so what when you're setting up this trust? Do you obviously have to have a business set up with the so you could just say, hey, I'm going to create Dan French Trust.
Oh yeah,
right?
yeah. You
and
don't
then,
have to have anything. Yeah.
right, and then you could just set up
legally.
What can you put in there besides properties? Anything you want?
See? I don't know
Your
what
checking account,
I don't know
your
what-
savings
yeah.
account, your
Well, yeah.
brokerage account.
My cars are in a trust.
You can do that. It's not. You don't necessarily have to. They have some easy procedures.
What if you don't
for
own your
cars,
car
but
though, and then you got to put it in there? Like the bank owns it.
That's
and-
okay because there are easy procedures dealing with a car when they're under a certain value. It's not so big of a deal.
I mean, you
if
can
don't get
open
your car
just
in a
open
trust.
bank. Just open bank accounts in your trust name. Now,
Yeah.
legally, it's kind of crazy because all that's required is that you not even write it down. You declare a trust. Don't ever do that because when you got into it, but that's really all the statute says. You have to do.
What validates it to be that it's a solid trust that's legit and it's what I mean, because obviously you're saying that
It could
signed
be as
writing,
it could be as
basically.
simple as a signed writing. Say, I'm transferring this to my trust. Sign.
I declare trust.
That's all the law requires. Again, I don't do it because it's an evidentiary problem, right? What if somebody challenged that and said, I don't believe that trust exists? I believe that's a fabric. So what you want to do is write it out, have you sign it, 2 witnesses sign it, and I'd notarize it too, just to prevent as much evidence as you can. That's a little technical, but my point is it can be as complex or as simple as you want it to be, just depending on your situation. People hear trust, and like you said, they think they got to make it with the state. No, you do with an LLC, which is, by the way, not that difficult either if you're a single LLC. But you don't have to declare to the state that you've made a trust. Yet it gets all the benefits that an LLC does when somebody like the IRS comes knocking on your door.
That's one of the big reasons why people love trusts, because you don't necessarily have to make your business public. It doesn't have to go before a court to transfer property when you pass away.
Why does more people not know about this stuff, though?
A lot of people know about this, I would say.
I think a lot of people do, but they also do stupid things like that one.
I think a lot of people, and I'm going to say this. I think it's not that they don't know about it, but a lot of people, of course, they don't like to think about their own mortality. So it's not that they're not aware that they should do something. They just don't for one reason or another because they don't like to think about their own mortality.
Right. Yeah.
Two, though, also, and this is something that comes up a lot, and I'm sure, it depends on what industry you're in. But, a lot of people think, I know what I'm doing. I don't need to pay an attorney to write up a deed or write up a will, or I can look up NOLO. I read NOLO, and I can do it myself.
I heard wills, though, are not, wills aren't that enforceable, right? You got a lot of problems. Like my parents, they inherited a home from my dad's father that passed away.
Okay.
I'm telling you, he was old school. He's like, I'm not doing a will. I'm just not going to do it. He goes, not a will, a trust. He goes, I'm just going to write a will. Wrote the will out. I'm telling you, it was like 8-month process. So just to get to a point.
That's probate.
That's probate.
And that's the problem. Yeah, it's probate.
But wills are perfectly valid. They hold up.
They work. You just got to go to a court.
But they're not. They're breakable, right? Aren't they?
What do you mean?
Well, like you can
if
on
you
a
did
trust,
it yourself,
right? If you have a trust, I think it's a little bit more solid than just saying, "Hey, I wrote out a will."
Well, you can. Here's the thing. If you're talking about, first of all, like you were saying, Rich, that idea that don't like to talk about your own mortality, but estate planning can affect you beneficially while you're still alive, like the things we've talked about with the IRS type of thing. So it's not death.
Oh yeah, no, there's definitely asset protection.
But I'm sorry, what was your question? No, I had a point you were trying to make.
Is a trust stronger than a will?
Okay. Second, it is extremely rare, if not impossible, to avoid probate completely. And that has to do with normally when you die, you have an IRS tax return, for instance, some sort of benefit. That's going to be written out in your name, not your trust name. So you have to go to probate to get that. But it can significantly reduce the amount of stuff you have to put through probate. So what I do, I don't know what you do, is usually I have a will and trust, it's just one document. And it kind of like works as so it's the same sort of thing with the trust in there. I know you can do it that way.
It's got a pour over will.
Yeah, we have the
pour over will. But usually it does. The trust is a term of art, and the will is just a term of art. So you use both documents, but I don't mean to bore you, Dan.
No. Well,
no,
I'm listening
over there.
I'm listening.
Here's the question. I mean, if I have a will or I have a trust, is the house going to go to that person? Now, I understand the will's got to probably be probated, and it'll take a bit longer, but it still is bulletproof as a trust, isn't it? In most cases.
I mean, I would think so for the most part. It's just. I mean, as long as they're a validly created instrument.
So this.
And that's the point. You said validly created instrument. And I believe in paying for good legal advice, like I like buying real power tools.
I'm charging. We're charging all you guys.
I mean, I definitely think. I think we're
about even because.
You're right.
No, I mean, I think the idea really is that having a trust, depending on your situation, is definitely probably going to be an easier process. But I don't know that I would necessarily say that it's
I would
more
say
legally enforceable. But Joe, what do you think?
I don't know.
I think what you got to sign up for is an iron will. That's what you need to sign.
Iron will, yeah.
But the thing with when you get a trust is you're still going to have a will. That's the thing, though. It's not like if you have a trust, you're still going to have a will, and you're going to have a will. Yeah, you're going to have a will that basically says anything I forgot to put in my trust, probate into my trust now that I'm dead. Yeah. So you're still going to have that will even with.
Yeah. So I would say, as far as a house, pretty much if you got a house real estate, I would say put it in a trust.
Put it in a trust
because this is what happens. Like a will's just fine, but what happens? Somebody dies. You take the will. You have to go to the court because can't get title. You can't own anything until you go to the court.
Right.
With the trust, what the trust says is like, all right, this is in the trust name, right? And by the way, when I die, whoever is the subsequent trustee will give title to XYZ. Yeah. They don't need to go to the court. And because it's recorded against the property, you can sell it as marketable title.
And it's immediate. You don't have to wait. I mean, basically, as soon as they...
Yeah, so you held up for 12 months. What if the property prices go down and then you lost out because you were stuck in probate trying to get this thing cleared?
Well, a lot of times, though, in a will, though, there's no guarantee that you get everything. I mean, what if that person had a lot of credit or a lot of things that they had to pay? Also, too, what if they had heirs? So now you got to send out these documents.
Well,
that
yeah,
says,
I mean,
you got to mail that out.
trust-
So it's not.
A trust benefits that, though. Now,
Well,
That's
but a
where-
will,
that's
a will
where it's
does
better.
too, though. I mean, a will. That's the point of a will, is it doesn't go to it goes to who you say it goes to. It only goes to their heirs if you don't have a will.
Well, okay, so this will was put out, and they said you got to mail out to everybody saying that.
What state were you in?
It was in California.
Okay, so each state has different laws.
Okay, so
it
was
doesn't
that
matter-
so
doesn't matter
Nevada's
what state
completely
you're in.
different?
It's
about
not completely different. It's just that each state does have its own law, so it doesn't matter. That's all.
yeah. Well, David, I mean, what? Sorry, you got about 5 years or so left in life. Have you have you handled all this yet? Or I'm just giving you a hard time. But any thoughts on this?
Hey, I got a question on this. How old do you think David was when you walked in?
26.
26?
About 10. Add 10 years to that.
Are you serious?
Yeah.
Dude, when he told me he was in his mid 30s,
You're 36?
Yeah.
36.
You're older than me?
How old are you? 34?
30. Yeah, this year. How you nailed it?
Whoa.
Jeez.
87. You told me your birth year, so
Yeah.
34.
Wow.
Yeah.
You're good at that math thing, aren't you?
I'm sorry. I thought you were like 25.
No.
You look good.
Thanks. No, I've been in real estate 16 years.
Oh, nice. Okay, cool.
Yeah, since 2005.
Well,
Okay.
getting back to the topic, clients will often ask me, Mike, do I need a will or do I need a trust? And what I usually say is, if you like your kids, get a trust. If you don't worry about it. How about that?
Yeah, that's a good way to put it.
What are the major differences between the will and the trust?
Or you have grandkids.
So,
All right, so
yeah,
you wanna-
explain what happens when, okay, Mike and his wife pass away. Mike's kids are the beneficiaries. What's the difference if we have a will versus a trust?
Well, I mean, I can definitely come up with a few horror stories. So like I'm gonna go with I'm gonna of course leave out all names and everything like that, but I'm gonna go with
To protect the innocent.
yes, to protect the innocent. I'll go with a fairly current case. We had a family that they have 8 kids in the family.
Oh my goodness.
And I believe that they did have a will, although it may have been unnecessary, because when you leave everything to your kids, that's what the law would do, basically, anyways, even if you didn't have a will.
Right.
But everything, their house went to their 8 kids. And so basically, there are 8 people on title to this house.
well, they had a will and it still went to your kids?
Yes, yeah. So, and I think they did have a will, but they
wow.
had 8. The house. So I mean, now the house
a nightmare.
passed. Yeah. So the house went to all 8 kids. So now, guess what happens when you have 8 people who own a house?
They all want to do something different.
Yeah. And so the way it actually came to our office was not through any of the estate planning, but one of the siblings. And then brought in 3 others. 4 of the siblings are suing 4 of the other siblings to allow them to sell the house. And so that's just one. That's just one of the many things that can go wrong.
Sure.
If you have a trust, you can say real easily, you're in charge. Child 1's in charge, and child 1 is going to sell the house as soon as we die and distribute the money.
Child 1 is the executor.
Child 1 is the executor and the trustee, and child 1 is going to sell the house and distribute the money so that it doesn't
Among all 8 kids.
doesn't end up being owned by all 8 kids, and they have to go to litigation to decide what to do.
And
with
that's
it.
really
How much
good.
does that cost? Bring into the law.
It wasn't that bad, actually.
but
In fact,
you're
it
still
actually
wasting
worked
money.
out well because the sibling who actually lived on the property got a settlement from an asbestos case and is able to buy out. the
Oh,
rest
well,
of the
that's always
siblings.
nice.
So it actually worked out nicely. No one had to sell and stuff like that. But
Well, and that's a good example. But I think, Mike, the best way to explain it is think of a trust like this. If you have a kid, right? And
I got 2.
all right, let's say you have high ambitions for them, right? And you're like, you guys go to Stanford.
Oh, best.
You graduate from Stanford, and I'll give you a car as incentive.
No, my kids are going to UNR.
Okay, yeah, that's even better.
Wolfpack, right?
So you tell
The University of
So you
Nevada,
tell your
right?
kid, look, dude, graduate from the University of Nevada, and as incentive, I'll give you a car, right? And you're alive. So you can make that decision whether you want to do that or not, because you're alive. That's easy. What a trust does is it gives you the ability to basically do what you want with your money as if you were alive, even when you're
Gone. Yeah.
that's what it
so
does.
one thing I do have a trust, and one thing I did in mine is I say, okay, when my wife and I die, kids get X amount of money, and then when they're 25,
Yeah.
they get X amount of money, and
Common.
when they get 35. Because I know an 18-year-old, if they inherit a big chunk of money, boom, it's gone,
Yeah,
right?
This is the other great thing about the trust, because with a will,
Controlling
that's it.
from the
Right.
grave.
I think I would have gone on a.
So
any
you guys
spooky
really
music?
haven't answered my question. Okay.
Okay.
All right.
What is better, a will or a trust?
Trust.
Yes.
Trust, a trust.
Okay.
But not everyone needs a trust. That's all.
Okay.
I mean, if you
If you don't have much of anything,
if all your assets is a stack of CDs, don't
Yeah.
worry about it.
Yeah,
that's
that's
all.
just-
What about old records that might be worth like $500,000?
Oh, if they're like,
Well,
you know,
if they're
original
worth that
Beatles
much,
albums, then
yeah.
yeah, those
I
should
just
be
was
put in the titled in the trust. Yeah.
Don't you
Title
also
your-
put medical instructions in there? Like if you're on life support and the family's going to make a decision?
That would be a healthcare directive, so that's a little bit different. But it is usually
Yeah.
usually we try to get people to do that when they come in.
Because I heard it's good not to
That's a
put
good
it
question, though.
not to put organ donor on your driver's license, but put it on your will.
Why?
I would put it in both places. So my mother-in-law was a recipient of an organ donation, and by having it on your driver's license,
They make an immediate response.
well, what happens is the bodies are treated a different way. Okay, and I'm just kind of speaking from personal experience. Yes, well, if I went to you today, Rich, and to get a trust, it's going to be. I'm not going to get just the trust. You're going to give me a set of different documents, and maybe you can kind of explain what those are.
So I mean, so I would say, so in our practice, and our wills primarily are for just to start off to be clear, ours are primarily for probate bypass. In my practice, we don't do a lot of asset protection and things like that. But in my practice, but what we would get you to do, probably if we felt that it was the right paperwork for you, is we'd try to get you to set up a trust, do a pour over will that comes with it. And like I said before, the will basically just says anything that I didn't put in my trust, or I forgot, or that I bought and didn't have time, probated into the trust and follow the instructions of the trust. And then there are these two other very important documents. One's called a financial power of attorney, and one's called a healthcare power of attorney.
And that's what David was
Yes,
talking
and that's
about.
what Dave was talking about. And so basically the financial power of attorney is kind of like it's almost like basically you give someone the right to deal with all of your financial assets,
And that's something that I deal
alive.
with in my situation. Sometimes a client will be in the hospital and a kid will come in with the financial power of attorney, and okay, I need to sell something so we can pay dad's bills.
And then a healthcare directive, which is it's kind of like a financial power of attorney, but about your healthcare. And they, you can basically designate someone like, well, for a lot of people, of course, they're going to designate their spouse. But especially if you're not married, and especially if you have family members that you don't trust or something like that, or you just have someone that but you want to have you have one or two people that you designate.
The one you don't trust.
Yeah.
Not the one you don't
Like
trust.
Dan, you
but
pull
I'm
the
saying-
plug
but I'm saying
immediately.
that's
Pull the
especially-
plug.
But no, but this
I'm
is
just
true
kidding,
though.
Dan.
A lot
I'm
of
just
people
kidding.
have next of kin that if you think about it, that's not the person you'd want
Or,
making decisions.
or you may
for
have a
you.
couple different kids,
Right.
and one's
and one of
kind
them's
of
and
strung out.
you want to make sure that the one that you trust the most, or that you think knows what
the one that likes you the most.
the one that likes you. Well, yeah. So those are important, but also too on that healthcare directive, there are certain questions that you get to answer ahead of time. That they give you certain situations that like if you are basically in a vegetative state and there's no hope, what should we do? If you're on life support and there's no hope, what should we do? And they give you these different questions so that you actually get to have a say ahead of time. Like if a certain situation arises, this is what I want done.
And the reason I think these are so important is it does give whoever's making that decision the peace of mind. This is what they wanted.
Yes,
Exactly.
And
very good
you're not
point.
sweating it.
Yeah.
Did mom
Exactly.
want me to pull the plug or not? I don't want to have that on my shoulders.
Yeah, and doing this for clients, it's always hard on the clients when they have to think about these things for their own life. But I'm like, it's gonna be hard on your son that you didn't give any direction.
Yeah.
And now he's got to make a decision. So